Fundamental right. Fundamental right are enshrined Part 3rd and Article 12 to 35 derived from Constitution of USA Bill of Rights. Part 3rd of Constitution rightly described as the Magna Carta of India. It contains a very long comprehensive list of justifiable fundamental rights. In fact, the fundamental rights in our constitution are more elaborate than those found in constitution of any other country. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They afford the equality of all individuals. So, right to equality 14 to 18, right to freedom 19 to 22, right against exploitation 23-24, freedom of religion 25-28, cultural right 29-30, right to property and constitutional remedy. So, 44 amendment, it is made legal right under the article 300A, that was the right to property, and that is under the 44 amendment hold as a legal right 300A and part 12 of the constitution. So the fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of authoritarian and despotic rule and protect the liberty and freedom of the people against the invasion of the state. They operate as a limitation on the tyranny of the executive and arbitrary law. So the fundamental rights are named so because they are guaranteed and protected by the Constitution. They are fundamental and also in sense of they are most essential. So fundamental rights, some of them available only to the citizen of India, and they are legal person like corporation and companies. They can all person whether citizen, so they can prevail it. They are not absolute but qualified. So these rights are the qualified, not absolute, and reasonable restriction can be imposed here. So reasonable restriction can be imposed here, and thus they strike a balance between rights of individual and the society as a whole, between individual and social control. Most of them are the available against the arbitrary action, with a few exceptions like those against the state action and against the action of private individual. When the rights that are available against the state action only are violated by the private individual. No constant remedy but only the ordinary legal remedy is there. So some of them are negative in character, that's why we can say it is negative in character also, and they are justifiable. You can even go for the court for the enforcement of this right. They are defended and guaranteed by the Supreme Court. They are sacrosanct, not sacrosanct or permanent. This is not sacrosanct. Without affecting the basic structure, you can change it, but basic structure should not be changed. Okay, and they are suspended during the operation of national emergency. So except the article 20 and 21, all other article can be suspended. Article 19 can be suspended only the ground of the external aggression and not the ground of armed rebellion. So external aggression hota hai, in that condition only article 19 can be suspended. The scope of the operation is limited by article 31A, law providing the acquisition of the state, validation of the act, and next is their application can be restricted by the military rule. So these article are like 33, 34, this is for the military purpose, and article 35 it is directly enforceable. Now next one is the definition of the state. Under article 12 you can see the definition of the state: government and parliament, government and legislative of the state, and all local authorities, all other authorities that is statutory like LIC, ONGC, SAIL. The state has not defined in wider for so as to include all of the agency. It is the action of this agency that can challenge it in the court. So according to the Supreme Court, even the private body or the agency working as an instrument of the state fall within the meaning of the state. Article 13 is declared that all laws that are inconvenient with or derogation of any fundamental right, you can go for shall, it is a void. Okay, so now doctrine of next one is Article 226, Supreme Court in 32, and the Article High Court 226 that can declare a law unconstitutional, and permanent law enacted by the parliament, temporary law like ordinary issues by the president, and statutory instrument is the nature of the delegated legislation. Now, right to equality, that was equality before law and the equal protection, prohibition of the ground of religion, race, caste, equal opportunities, matter of the employment, abolition of the untouchability and abolition of the military academic जो भी title है. Right to freedom, protection of the sixth right, speech, expression and the assembly, association, movement and profession, protection of the respect of the conviction of the offense, protection of the life and personal liberty, right to elementary education, and protection against the arrest and detention, right against exploitation, that was prohibition of the trafficking in the human being and forced labor, and the prohibition of the employment of the children in the factory. Religious, like freedom of the conscience, freedom of the managed religious affair, freedom from the payment taxes, and freedom from the attending religious institution or workshop. Cultural and educational right, protection of the language, script and the culture, right of minority, that was the establishment of the minority institution, right to constitutional remedy, that was enforcement of fundamental right included habeas corpus, mandamus, quo warranto, certiorari. Now next one is prohibition of discrimination of the ground of the religion, equality opportunities, protection of the rights regarding the freedom of assembly, association, movement and residence, protection of the language, script and culture, right of the minority establishing and administer the educational institution, equality before law, protection of the conviction against the conviction, protection of the life and liberty, right elementary education, protection against the arrest and detention, prohibition of the trafficking, prohibition of the employment of the children, freedom of the concise free profession, freedom of the manage the religious affair, freedom from the payment of the taxes and freedom from the attending the religious institution से कोई भी. Now equality before law and equal protection of the law. So article 14, this provision was confer the right on the all person whether citizen or foreigner. Moreover, the word person include the legal person, statutory corporation and the companies. The concept of equality before law, equal protection of the law, and that was given. So second concept of the order, other hand, equality of the treatment under the equal circumstances. The similar was given, all person was similar situated, the like should be treated alike without any discrimination. The Supreme Court held that the whether equal unequal are the treated differently. So now next one is the concept of equality before law and rule of law, that was dicey. Absence of arbitrary power, that is no man can be punished except the breach of law. Equality before law, that is equal protection of the citizens and the primacy of the right of the individual, that constitution in the result of the rights of the individual as a defined and enforced by the court. Now exploitation, exception of equality, the president or the governor is not answerable to any court, exercise and performance of the power and the duty of his office. No criminal proceeding shall be instituted, and now no process of the arrest or imprisonment president or governor shall be issued from any court. No civil proceeding against the president and governor, and until the expiration of 2 months next after notice has been delivered to him. So civil proceeding until the 2 months. Now no person shall be likely to any civil or criminal proceeding in any of the respect of the publication, newspaper, television report of any proceeding, either House of Parliament. No member of Parliament shall be liable to any of the proceeding in any court respect to vote of the Parliament. No member of the legislation of the state shall be liable to the proceeding in any court in respect of anything said to be the given him legislation of committee. Article 31C, in the exception of Article 14, it is providing directive principle of the state policy. Article 39 cannot be challenged. Article 14, Supreme Court held there was a given, and foreign sovereign ambassador diplomats enjoy the immunity from the criminal and civil proceeding. UNO and its agency enjoy the diplomatic immunity. So prohibition of the discrimination on ground. Article 15 provides state shall not discriminate against the citizen on ground of the religion, race, caste, sex and place of birth. Two crucial words. Discrimination means make a distinction between a distinguished unfavorable from other. So the state permitted to make any special provision for women and children. For example, local bodies provide free education. The state is permitted to make any special provision for the advancement of the socially educationally backward classes, and empowered to make any special provision for the advancement of socially and educationally backward classes. It laid the 93rd Amendment order to give effect of this provision. So 27% दिया गया था ओबीसी को. नाउ क्रीमी लेयर क्या होता है? सो क्रीमी लेयर होते हैं यहाँ पर, एंड नाउ इक्वल अपॉर्चुनिटीज़ भी दी गई. आर्टिकल 16 इज़ प्रोवाइडिंग द इक्वल अपॉर्चुनिटीज़ ऑल सिटीजन इन मैटर ऑफ द एम्प्लॉयमेंट और offer under state. So parliament can prescribe the residence as a for the certain employment, and the public employment required there. Okay, the state can provide for the reservation of the appointment of the post favor of the backward classes, and a law can provide the incumbent of an office related to the religious denomination of the should be belong to the particular religion. Now Mandal Commission आया था. This Mandal Commission was in 1979. So that was मोरारजी देसाई गवर्नमेंट. एंड सेकेंड बैकवर्ड क्लास कमीशन भी कहते हैं इसको. मंडल इज ए आर्टिकल 340 कॉन्स्टिट्यूशन इन्वेस्टिगेट द सोशली एंड एजुकेशनली बैकवर्ड क्लासेस. द कमीशन सबमिटेड रिपोर्ट 1980 आइडेंटिफाइड मैनी क्लास 52% कंपोनेंट ऑफ द पॉपुलेशन एक्सक्लूडिंग SC/ST, एंड ये टोटल को मिला के 50% होना चाहिए. VP सिंह गवर्नमेंट ने इसको 27% कहा था. देन ये रिजर्वेशन अनदर 10% जो है इकोनॉमिकली बैकवर्ड क्लासेस जो हैं उनको देने की जो इकोनॉमिकल क्राइटेरिया है इसमें 10% रिजर्वेशन आया. ओके, द मंडल केस दैट वाज आर्टिकल 16 and 4 and that was in 1992 for the backward classes. 10% is the poorer section and the higher caste. 10% reservation is given. The advanced section among the OBC excluded from the no reservation promotion reservation should be confined, and the total reserved quota is 50%. Extraordinary situation carry forward rules is also there, and permanent statutory body should be established to examine the complaints. So now Ram Nandan committee that was appointed for the creamy layer. A national commission for backward class in 93 parliament considered the inclusion or exclusion of the caste, and under article 77 amendment enacted, it added a new provision of article 16 to empower the state to provide for the reservation of the promotion of any services, and that was 85 amendment provide the consequential seniority. And the ruling with regard to the backward vacancy 81 amendment act was it added the article 16 determining the ceiling of the 50% reservation of the total vacancy. 76 amendment that was placed the Tamil Nadu as a judicial review. Now next is abolition of the untouchability, that was under Untouchability Offence Act 1955, protection of the civil right to enlarge the scope and make the penal provision. And article 17 of the constitution, the term untouchability had not been defined. However, the Mysore High Court held that subject matter of article 17 is not untouchability. So there was under the provision of civil right, and there is a fine of 500 rupees too, preventing any person from entering the place public worship, justifying untouchability, insult करना या फिर refusing the person, and preaching untouchability. Abolition of the title, it provides the state from the conferring the title. A foreigner holding any office of the profit of the trust under the state cannot be accept any title. No citizen or the foreigner holding any office, profit or trust under the state accept any present or title. So that was article 1996 में Supreme Court upheld the validity of the national award like Bharat Ratna, Padma Bhushan, Vibhushan and Padma Shri. It ruled the three awards do not amount the title within the meaning of article 18 that prohibit only the hereditary title of nobility, therefore not violative, and the theory of equality does not mend it. Now next one is what? Protection of the sixth right. Right to freedom of expression, right assemble together, association, move freely, reside and settle in any part, practice and profession. Article 19 contains the 7 rights, but a right to acquire hold of the property, that was deleted, and these rights are protected against only the state action and not the private individual. Moreover, these rights are available only to the citizen and to shareholders of the company. So the state can impose a reasonable restriction of these six rights. Now next one is the right to propagate one's view and freedom of the press, freedom of the commercial advertisement, right to telecast and band, these all. Freedom of the assembly, so that was also provided for the public meeting and demonstration and the procession. And under the article section 144 criminal procedure code, a magistrate can restrain an assembly meeting in the procession if there is a risk of the obstruction. Under the section 141 of the Indian Penal Code, as a person become unlawful, resist the exclusive and low legal process. Freedom of association, all citizens have the right to form association and cooperative society. It includes the right to form political parties and companies for the society. Now next is freedom of movement. This was the freedom entitled every citizen to move freely, and he can move freely from one state to the another state. Next one is freedom of the residence. Every citizen has a right to reside and settle any part of the territory. This right is two part: the right to reside in the country within, which means to stay any of the place, and the right to settle in any part of the country. Freedom of the profession, that was also provided here, and that was this right are the very wide and prescribe the professional and technical qualification carry further itself for the trade and business. Thus, no objection can be made when the state carry on the trade, business, and industry. So, this right does not include the right to carry. Protection respect to conviction of offence, Article 20. No ex post facto, but no person shall be convicted of any offence except the violation of the law commission, subjected to the penalty. No double jeopardy. No person shall be prosecuted and punished for the same offence more than once. And no self-incrimination. No person accused of any offence shall be compelled to the witness against itself. The law of the impose the penal and the retrospectively. So the enactment of such law is prohibited. And now the protection against the double jeopardy, it's available only in the proceeding before the court and not available proceeding before departments. The protection against self-incrimination of the oral evidence and the documents evidence are also there. Now next is protection of life and personal liberty. The protection article was available only against the arbitrary executive actions, and this means that the state can deprive of right to life and personal liberty of the person based on the law. This is because the expression process is established by the law, Article 21, which is different from the expression due process of law. And the personal liberty means that liberty relating to the person on the body of individual. And now there is a Gopalan case that was taking the wider interpretation, and therefore it is ruled the right to life and personal liberty. Due process of the law, the protection of the Article 21 should be available, not only the arbitrary execution but also the arbitrary legislation. The right to live, human dignity, right to decent environment including the pollution free, right to livelihood, right to privacy, and right to shelter and health. Right to education, that was Article 21 of the Constitution, 86th Amendment, education for the whole. And 45 article that was given, it shall be the duty of every citizen to provide the opportunity for the education to his children 6 to 14 years. 1993 itself, the Supreme Court recognizing the fundamental right to the primary education and right to children free and compulsory education. Now there is a protection against the arrest and detention, that was the punitive detention and the preventive detention. Right to inform of the ground of arrest, right to consult the defendant legal practitioners, right to produce before the magistrate 24 hours, right to release after 24 hours of the magistrate authority. These safeguards are not available to the enemy alien. The Supreme Court also ruled that the arrest and detention do not cover arrest under order. Now the second part of the 22 is grant the protection a person who is arrested, detained under the preventive detention, and this protection is available to both citizen as well as the alien. The detention of the person cannot be exceed 3 months unless the advisory board reports, and the ground of detention should be communicated. The detainee should be opportunity to make the representation against the order. Article 22 of the Constitution, Preventive Detention Law Advisory Board is there. So 44 amendment was reduced in period of the detention. Now there was a 2 month. The Constitution has divided the legislative power regard to the preventive detention between the Parliament and the make a law the preventive detention. The Preventive Detention Act was expired in 1969. Maintenance International Security MISA and COFE COSA NASA TADA that was in 95, and the prevention of illicit trafficking that was 88.